This courtroom session begins in a procedural tone, but it quickly unfolds into a much more complex situation involving bond violations, tether monitoring issues, and conflicting explanations from the defendant. What seems at first like a routine appearance soon reveals deeper concerns about compliance, credibility, and supervision conditions. The defendant is already under monitoring, yet new concerns are being raised about behavior, movement, and possible rule violations. The judge is clearly alert. The probation officer is concerned, and the defense is attempting to explain away the situation. But the real tension here is simple. Is this just an innocent technical issue, or another sign of repeated noncompliance? Let's break it down.
His socks slide up underneath the tether on his ankle. And he showed it to me, and yes, they do. Soberly might be a better idea.
So what's his sock sliding under have to do with him being a farmer?
Because he's out in the field all the time.
I just, the way I work and have to crawl under equipment to maintenance it and grease it, and the socks might move and it can get wedged between the.
I mean, he's an actual farmer. I used to think all the food you get grows at Kroger's, but it grows it on the farm.
Okay, that's nice. However, Ms. Lundy, you wanted to say something? I'm sure.
I spoke with Mr. Vincent about this earlier, and I suggested that perhaps the court may entertain a sober link, but I would be looking to have more than just the 2 tests that are usually done on a sober link. If the court is to order one, I ask that we look at potentially more. And Mr. Vincent informed me that because the defendant's work requires him to be out in the field, he may not.
At this stage, the court shifts into a critical legal decision regarding monitoring conditions. The prosecution raises concerns that a standard sober monitoring system may not be sufficient, especially given the defendant's work environment and mobility in the field. This is where legal supervision tools like Scram or SoberLink become important. They are designed to ensure real-time compliance through alcohol testing and location accountability. The judge expresses clear skepticism about the explanation involving the ankle tether and socks, essentially questioning its credibility. In court terms, this matters because if a defendant is already under supervision and there are doubts about compliance, the court can increase monitoring intensity or impose stricter conditions. The judge is essentially weighing trust versus enforcement. Do you think the explanation about the tether issue is believable, or is the court right to be suspicious?
So hold on a second. First of all, I'm just going to let you know. The sock story, I don't believe it for a minute. And only because I've got plenty of people that are on a Scram tether that wear socks. And the socks don't just jump under the tether. And I don't think farmer socks are any different.
I understand. You know, I know this court. I know, Your Honor, for a long
And you
time.
know this look on my face is one of absolute
I don't
disbelief.
even have to look at your face to know the look on your face. He's willing to, I ask him point blank, you better not lie to this judge.
I'm not lying.
And he's willing to take an ETG test.
I can send him back there, and we got a guy back there that did it today.
That lied.
Oh yeah.
I warn everybody. Everybody. Don't dance when you come in here.
Don't think you need to have a warning.
Yes, they do.
So that's why I don't believe this. I don't.
He
think it's
showed
a-
it to
I
me.
don't. Think
I could show that.
But Mr. Vincent, I don't think it's a sock thing. And let me just tell you how I'm putting this together in my head. I've got somebody on an OWI3 who has a tamper on a Scram tether, who then, when I would be potentially putting on a sober link.
This is where the courtroom tone becomes more direct and confrontational. The judge openly states disbelief regarding the defendant's explanation, emphasizing that similar monitoring issues have been seen before in other cases, making the sock under tether argument highly questionable. The court highlights a key legal concern: tampering or attempted avoidance of monitoring conditions. Even if not proven, perceived noncompliance is enough to influence judicial decisions at this stage. The judge then presents a clear choice: either accept a stricter sober link system with multiple daily alcohol tests or face a full hearing on the alleged tampering, which could result in jail pending review. This is a classic courtroom pressure point: cooperation versus detention. The defendant ultimately agrees to the sober link option, prioritizing freedom over contesting the allegation immediately. But the underlying issue remains: can compliance truly be trusted moving forward?
Yeah, no, I can't go to jail, so I guess it's a sober link.
Oh, no, you could go to jail.
It's harvest time. That's what he means.
Yeah, I have animals to take care of, and yeah, so I'm trying to stay out of jail.
So does that mean he'll take a sober link 4 times a day?
Sure. I'll even take it a couple times a day.
Yeah, but that, we know how that is. Can you get out to the order? So I'm not going to set this because I want to make sure that he's going to make it through this. I'm going to adjourn this 2 weeks out, then I'll set the prelim.
Okay.
But I'm not setting it. Well, so I'm signing the order. You're to go over and be placed on a sober link device. You'll be on the sober link, no miss test. Bond will otherwise continue. Thank you.
Appreciate you. He does. I'm going to explain to him how much he appreciates you.
Thank you.
Leave me out in the hallway.
Hello, Taylor
Hello.
Norman.
Okay. Hello. Are you going to represent yourself or what are you doing?
Yes, Your Honor, I haven't yet retained an attorney. I had filed a motion for discovery on October 25th. So I was waiting to get that back to retain my attorney and go forward with that.
So you didn't know how to send it to the prosecutor's office to get discovery?
No, I did send it to the prosecutor's office. I sent it via email and I dropped off a paper copy, but originally on the case, it had
What
said,
email did you send it to?
I had called, I don't know off the top of my head, but I can
Oh, you
check.
called?
Yeah, I called to see which email to send it to, Your Honor, and they told me. And then I also brought in a paper copy and gave it to the felony clerk as well. But it had originally said that Barr was the judge on the case. So I have an extra copy here if you need this, but I did send it via email and bring in.
I have your. So what do you want me?
In the second half of the hearing, the focus shifts away from monitoring and into legal process management. We now see a separate defendant dealing with discovery issues and legal representation concerns. The court emphasizes procedural fairness, ensuring the defendant understands the importance of legal counsel and proper submission of discovery requests. The public defender steps in, and the court grants a short adjournment to allow proper preparation. Then another case is addressed involving restitution. Financial obligations are central here. The defendant owes approximately $3,400, with only $900 paid so far. The court carefully breaks this down and sets expectations. Progress must continue, with a target of at least 50% payment before further leniency is considered. The judge ultimately adjourns a matter to allow time for payments, emphasizing consistency and accountability rather than immediate punishment. This entire session highlights a broader theme in the justice system. Courts are not only enforcing rules, they are constantly balancing rehabilitation, compliance, financial responsibility, and fairness. So the question is, should courts prioritize strict enforcement or allow more flexibility when defendants show partial progress? If you found this case insightful, make sure to like, share, and subscribe for more detailed courtroom breakdowns and real case analysis.
Yeah, but if Your Honor.
Just let them quick, that's a we'll
Okay.
order it and get it to you.
Okay.
Put
I just
address,
promise I
phone
did.
number, and email on there.
Right here.
Yes, where it says notes.
Okay, this is a public defender case now. That's what she wants.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with it on behalf of Ms. Norman. Your Honor, we'd ask for a couple weeks adjournment so we can get the discovery and speak with her. And if she seeks to retain counsel, then we can coordinate that.
Okay. That was easy.
Yeah.
Sorry, I'm like shaking.
November 21st, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Just step behind that door there, the little short door on the other side of the bar.
Brian Bowling on behalf of Mr. Stewart, Your Honor. State your name for the record.
Keith Stewart. Thank you.
Your Honor, we're asking for an adjournment to allow Mr. Stewart to continue paying restitution in this matter.
Okay, that's right. So where are we now on it?
900.
You're at 900 now? And how much were we looking at? I thought I wrote it down.
For the 34, which would be 1,700.
The total is approximately $3,400, Your Honor. I did speak to Ms. Lundy today about maybe moving forward at a lower number, which she will consider, she indicated to me, but there's no guarantee.
So, okay, but to get us to a certain point, he was to get to 50% of the amount? Was that it?
Your Honor, just this afternoon, Mr. Bowling asked me if I would consider doing it before the full restitution was paid. So our agreement was to do it when the restitution had been paid. I said I wouldn't even talk about it until we had at least 50% paid.
That is accurate, Your Honor.
So.
Oh, well, you didn't say all that.
Well, I did believe.
No, you didn't say all that.
Okay, well, then
Made it sound like Miss Lundy did this, and then I asked her something, and then she kind of blew me off and said, "I'll do whatever." That's not what happened.
I misspoke. Then that is correct. What she said is correct. We discussed it today, and she said she would think about it or at least consider it once we got to that stage. I thought that's what I said. Maybe I didn't.
Alan, is that what he said? Close? Oh, you just give in on anything.
I appreciate
Emily, is that what he said? No. You abandoned me? Really? Okay, that's not what I heard.
Fair enough.
So that's what I'm gonna go with. Mr. Stewart?
Yes.
Okay. If we're going to at least this halfway point, that might change because I don't know what. So you're at 9 now.
Correct.
And so it's another 8.
Correct.
To get to that point. So how much time are you looking at trying to do that? I know you've been working hard on this as we've been kicking this out. So I'll work with you as best I can to try to get you.
I've been able to make $100 a week on average. So I will try to.
You'll be able to pay $100 a week on average, you think? Okay. So I'm going to adjourn it out to December 26th. Okay. That should be enough time to get certainly to the half plus some. So, and then that way, then the attorneys can talk and your attorney can tell me something that didn't happen again.
That's what I try to do all the time.
26, 9 a.m.
Thanks, man.
Bond will continue. Thank you, sir. Kinda, really, man. And then Emily, I'm out. I'm not. Court calls the case. People versus Devin Tatum. Boy, it was nice having my staff stick with me.